Hello, welcome to EPG Pathshala. My name is Mahua Nigudkar and I am a faculty with the School of Social Work, Tata Institute of Social Sciences, Mumbai. The module that we are going to cover today is non-institutional care. This module is part of the paper on juvenile justice within the overall subject of criminology. Now let us go back to this module on non-institutional care. All over the world, it has been proved that institutional care must be the last resort for children. So one of the core principles of juvenile justice system is, and I repeat, institutionalization must be the last resort for children. Various research studies across the world have proved that there are negative impact when children are admitted, especially in long-term institutional care. And therefore, non-institutional options such as adoption, foster care, sponsorship, alternative care and other community-based efforts are most favorable for the child. It prevents unnecessary institutionalization of the child. This module on non-institutional care examines the different provisions within the Juvenile Justice Act 2015, which elaborates upon the non-institutional approach. This module, I must state, has been largely based on the Juvenile Justice Care and Protection of Children Act 2015. As different states may have formulated their own juvenile justice state rules, it is suggested that you either read the model Central Juvenile Justice Rules or your own state juvenile justice rules as the case may be, and thereafter build a comprehensive understanding on what are the provisions for alternative care and what are the operational mechanisms that have been given in the state rules for a better understanding of this topic of non-institutional care or alternative care. So let us first start to understand what is institutional care before we move on to non-institutional care. Institutional or residential care facilities for children are facilities wherein children stay for short term or long term and for different reasons get admitted into these residential care facilities. These facilities primarily offer shelter, food, health care, clothing, other medical needs and educational requirements. There would also be another range of facilities depending on each need, on unique needs of the child and priority areas, as well as depending on the duration of the stay in the children's home or any such facility. Now there are state facilities or state homes rather within the juvenile justice system, such as the observation home, the special home, the children's home, and there may be other such homes as well. Some of the homes are fully funded by the state government or other resources. Some of the homes are mandates of the Juvenile Justice Act 2015. Some may be other kinds of homes being run by NGOs or civil society or other organizations. Within the Juvenile Justice Act 2015, it has now become mandatory that all residential care homes, irrespective of whether they are governmental or voluntary or non-governmental, irrespective of whether they are availing of state funding or not, they will need to get registered under the Juvenile Justice Act. Now within the juvenile justice system, the broad categories of residential care facilities would be some of the mandated institutions for children. Now for children in conflict with law, there would be the observation home. This is a residential care facility primarily for temporary admission of children in conflict with law. Then we would have the children's home. These would be residential care facilities for child in need of care and protection, both for temporary and long-term care, as the need may be. Then we also have places of safety. Places of safety are facilities primarily for child in conflict with law, who have completed 18 years of age and who need to be kept in such a facility till other orders are happening. as I was mentioning, there are some mandated facilities within the juvenile justice system for both child in need of care and protection and child in conflict with law. Apart from the institutions and homes that I have just mentioned, there are also another range of facilities, child care homes, which may come under the broad ambit of child care institutions. Now, within the Juvenile Justice Act, a child care institution means children's home, open shelter, observation home, special home, place of safety, specialized adoption agency, a fit facility recognized under the Act for providing care and protection to children. So, there would be many such homes, and there is a specific definition of child care institutions, and the JJ Act also explains which child care institution is required for what purpose. Now, what is non-institutional approach or alternative care? Non-institutional approach to care or alternative care, please let me emphasize, is not a mere substitute to institutional care. Rather, it is a range of facilities and services that reach out to all children who are without family or family support and can avail of non-institutional care facilities instead of being institutionalized. By that I mean the child can either stay in his or her own family with guardian, or if family or guardian is not possible, then a child can stay in a family-based or a family-like environment. So, as I was mentioning, that there would be children ideally who will be staying with their family, but in situations where children cannot stay with their family or guardian, then they can stay in a family-like or family-based environment. The non-institutional approaches within the context of the Juvenile Justice Act are adoption, sponsorship, foster care and aftercare. And along with the Juvenile Justice Act, there are many legislations and schemes that pertain to non-institutional or alternative care. Now, what is the framework for non-institutional or alternative care? I will quickly enumerate. The Constitution of India is the overarching framework for child-related laws, legislations and policies, including children who can avail of non-institutional or alternative care. So, there are several provisions within the Constitution that protects children from abuse and exploitation. So, other than the Constitution of India, which is the overarching framework, there are several laws and legislations pertaining to adoption. There is the Convention on the Rights of the Child, the CRC. This is an UN document which has been ratified by India, which again also includes the non-institutional approach to children growing up without family or family care. The Convention on the Rights of the Child enumerates a whole set of rights for every child, irrespective of their age, gender, identity, locality, spaces and any other circumstances. Then we move on to Integrated Child Protection Scheme, ICPS. The Integrated Child Protection Scheme, one of the largest schemes initiated by the Ministry of Women and Child Development, Government of India, has also a very specific measures to strengthen non-institutional, family-based care and community-based initiatives. So, please do read up on the ICPS. Then we have the National Policy for Children 2013. This policy too includes the child's right to a family and non-institutional care for children who do not have family. Finally, we come to the Juvenile Justice Care and Protection of Children Act 2000, which I will go into greater details in this module. Further, some of the more recent developments have been regulations related to adoption put forth by CARA in 2017, the foster care guidelines formulated by the Ministry of Women and Child Development 2016. So, these become the overarching framework when we talk about children in non-institutional care or alternative care. Now, let us move on to another very important international development, alternative care and the UN guidelines. The General Assembly of the United Nations at their 64th session, 24th February 2010, adopted a resolution titled Guidelines for the Alternative Care of Children. Alternative Care and UN Guidelines. The guidelines emphasize that family is ideally the best place for the child. However, in situations where the child's own family is unable, even with appropriate support, to provide adequate care for the child, or abandons or relinquishes the child, the state is responsible for protecting the rights of the child and ensuring appropriate alternative care with or through competent local authorities and duly authorized civil society organizations. It is the role of the state, through the competent authorities, to ensure the supervision of the safety, well-being and development of any child placed in alternative care and the regular review of the appropriateness of such care and the care arrangements appropriateness. Now, the guidelines also further state, and I would like to quickly touch upon it, that all decisions of each and every child must be taken on a case-by-case basis, based on non-discrimination, gender perspective and best interest of the child. Then they have also touched upon the role of the state. The role of the state is to develop and implement comprehensive child welfare and protection policies within the framework of their overall social and human development policy, with attention to the improvement of the existing structures and facilities specifically relating to alternative care provision, and also ensuring that it reflects the principles contained in the present guidelines. So, do look up the United Nations guidelines. It is available on the internet and you will get much more of information. Now, going back to these guidelines again, in section 29 of the UN guidelines, different forms of alternative care have been explained. The guidelines state that alternative care may take the form of 1. Informal care. Now, what is informal care? Well, it is any private arrangement provided in a family environment whereby the family is looked after on an ongoing or an indefinite basis by the relatives or friends. So, it is also informal kinship care, or by others in their individual capacity at the initiative of the child, his or her parents or other persons without this arrangement, but having been ordered by administrative or judicial authority or a duly accredited body. So, this is informal care. Do read up for more details. Second form of care is formal care. That is all care provided in a family environment which has been ordered by competent administrative authority or judicial authority, and all care provided in a residential environment in providing private facilities, whether or not as a result of administrative and judicial measure. So, ensuring that all the facilities of standards of care are also being met and the guidelines have certain measures on it. The guidelines further state that there could be other types of alternative care based on the environment where the care is located. So, then we have kinship care, family based care within the child's own extended family or with close friends of the family known to the child, whether formal or informal. So, the forms of care may be formal or informal. Environment would also indicate the type of care. The second type of care would be foster care. Situations where children are placed by competent authority for the purpose of alternative care in the domestic environment of a family other than the children's own family that has been selected, they are qualified, they are approved, There are norms of supervision providing such care, so the UN guidelines have spoken about it. Then the other forms of family-based or family-like care placements would be and include residential care in child care settings provided in any non-family based group setting care, such as places of safety for emergency care, transit centers in emergency situations, and all other short and long-term residential care facilities, including group homes. So, you have formal care, you have informal care, you have family-based care, you have family-like care, you have group homes, and then also you have supervised independent living arrangements for children. So, again I would reiterate, do look up the guidelines. The guidelines also mention steps to be taken to promote parental care, prevent family separation, and promote family reintegration. The guideline also very importantly elaborates upon the role of the state in setting up mechanisms and procedures to strengthen and enhance the scope of alternative care through relevant policies and programs. Let's go to section 30 of the guidelines. In section 30 of the guidelines, it is mentioned that the scope of alternative care as foreseen in the present guidelines, however, does not extend to children who have allegedly committed offences and who would be considered as child in conflict with law, and these children are covered under other United Nations regulations and United Nations guidelines. The second group that the alternative care guidelines does not cover are children whose adoption processes are complete. The alternative care guideline believes that, and rightfully so, that once the adoption processes are complete, the child is legally with a family and the child will now grow up with family and under parental care. Hence, such a child whose adoption processes have been complete are no longer considered as children under alternative care. These children may be in alternative care when processes of adoption are happening. But once the process of adoption is complete, the child has a legal family, all inheritance rights, and as I mentioned before, the child grows up with parents and an adoptive family. Hence, these children are not under alternative care. Another group of children wherein they will not come under the scope of alternative care are children who may be voluntarily staying with their friends or relatives or guardian for recreation purposes. So, the scope of alternative care is very wide, and there are certain groups of children who may not come under this scope, and the reasons have been stated before. Now, coming back to the Juvenile Justice Care and Protection of Children Act 2015 and the specific provisions related to alternative care. This act is, as I have mentioned before, and you would have read it or seen it in the earlier models, is based on the Constitution of India, Convention on the Rights of the Child, other United Nations conventions. All of these have been integrated within the Juvenile Justice Act. The Juvenile Justice Act and the Juvenile Justice System makes provisions for alternative care in different sections of the Juvenile Justice Act. Now, let's go back for a moment to the general principles to be followed in the administration of the Juvenile Justice Act. As has been mentioned in earlier modules, these principles form the framework for the juvenile justice system. Specifically coming to alternative care or non-institutional care, I would just touch upon a few principles. Principle of family responsibility. That is, the primary responsibility of care, nurture and protection of the child shall be that of the biological family or adoptive family or the foster parents, as the case may be. A very important principle that governs alternative care or non-institutional services. Yet another important principle is that of the principle of positive measures. All resources are to be mobilized, including those of the family and the community, for promoting the well-being, facilitating development, identity of the child, ensuring an enabling environment, reducing vulnerabilities, Very, very important principle. Then we have principle of institutionalization as a measure of last resort. And this principle you would have read or you would have come across in several other modules. One of the key premises of the JJ Act 2015 is that all provisions are in the best interest of the child and the approach has to be a child-friendly approach. And there is a very, very specific definition within the JJ Act on what constitutes best interest of the child and what constitutes a child-friendly approach. So do look up these provisions because these forms the basis for any of our action within the juvenile justice system. Now moving on to this module of alternative care or non-institutional measures. There are very, very specific key terms, important terms and definitions specifically pertaining to alternative care and non-institutional services. Now all of these definitions have been given in the JJ Act 2015, such as the definition of adoption, what is adoption, what would be the process of adoption, who would be the adoptive parents, what is an authorized foreign adoption agency, what would be the regulation authority. So we have the Central Adoption Resource Authority. Now what would be their role, what would be their mandate. All of this has been defined within the Juvenile Justice Act, and there is an entire chapter in the Act which specifically deals with adoption. Then you have authority. Who would be the authority which would govern all the adoption processes in interface with the juvenile justice system. Then we have terms such as a child legally available or free for adoption. We have terms such as inter-country adoption. So what would inter-country adoption entail? Then we have terms such as prospective adoptive parents and the definition of prospective adoptive parents. Then we also have institutions such as who would be a specialized adoption agency, what would be their mandate, and so on and so forth. Then there would be many other terms such as surrendered child. Now who would be a surrendered child, who would be a relinquished child, and these terms become very important for us to understand, because without specific understanding of these terms we really cannot move on much. Then you have terms such as foster care, you have terms such as sponsorship, aftercare, then you have terms such as the District Child Protection Unit, then you have terms such as a foster family, who would be a foster family, how would they be identified. Then you have also very important terms such as group foster care. So what are these group foster care facilities for children who are growing up without family or family support? What would be the basic requirements of group foster care? Then you have also terms such as sponsorship, what would be the sponsorship facilities, who would be the sponsor. Then aftercare. Aftercare is again another very critical non-institutional or alternative care, specifically for children who come out of children's homes, who come out of special homes and have still do not have the necessary family support to go back to. You also have terms apart from whatever I have already mentioned before, terms such as the open shelter. Now we really need to understand terms such as open shelter, we need to understand terms such as place of safety, who are these places meant for, which group of children within the juvenile justice system are entitled to these kind of facilities. All of these terms and definitions have been given in the JJ Act. Do read up the JJ Act, do read up the write-up which is given within the module. Yet another important term would be the special home. Special homes are meant for children in conflict with law, and a small number of children go into the special home as per orders of the Juvenile Justice Board. Definition of a special home, facilities that have to be made available in a special home are also given in the Act. Then there is also another term called fit facility. So what are these fit facilities? Fit facilities are not mandated institutions within the juvenile justice system. Nonetheless, there are institutions which can be recognized, or facilities which can be recognized as a fit facility. A key stakeholder within the juvenile justice system and to better implement non-institutional services or alternative care is the District Child Protection Unit, which interfaces with the juvenile justice system. Now there are certain key provisions within the Juvenile Justice Act. There are different chapters in the Act there are different sections of the Act which specifically pertain to adoption, foster care, sponsorship and aftercare. So please look up these specific sections of the Act. There are certain specific chapters which deal with adoption. There is a chapter which deals with rehabilitation and social reintegration. Now, unless and until we read these chapters, we read these different sections of the Act, our clarity on non-institutional services or alternative care may not happen as much as expected. So while we understand that non-institutional services or alternative care pertain to adoption, pertain to foster care, sponsorship, aftercare, other community-based options and services, there are specific definitions of all of these non-institutional or alternative care within the Juvenile Justice Act. So read up the write-up which is given within this module so that your understanding becomes clearer. Now, along with these specific provisions, options which are given within the Juvenile Justice Act, we would also like to understand that adoption, foster care, sponsorship, aftercare is also part of the mandate within the Integrated Child Protection Scheme, ICPS. Now, there are other modules within this paper on juvenile justice which gives you the details of the procedures related to adoption. So, do look up those modules also on adoption to gain clarity. The other thing that I would like to mention is, do read up the Integrated Child Protection Scheme, because this has many provisions and measures wherein we can strengthen adoption, foster care, sponsorship, aftercare. We can prevent children from getting into institutional care. We can prevent family disintegration and keep the child with the family. So this is very important for us to understand. Along with the Juvenile Justice Act, do look up the United Nations guidelines on alternative care, because these are a set of guidelines that will guide all our thoughts, all our actions on alternative care or non-institutional care. So in summary or in conclusion, I would like to very briefly touch upon 2-3 points. Point 1 is, all across the world, there is an acknowledgement and there is a firm conviction that institutionalization must be the last resort for children. When children grow up in institutional care, they grow up often without a sense of belonging. They grow up with a feeling of isolation. They grow up cut off and isolated from mainstream society, often in large institutions where the infrastructure is not adequate, where there are not enough caretaking staff and other facilities. Such institutions can often become the sites for neglect, sites for abuse, sites for exploitation, though the Juvenile Justice Act very clearly prohibits abuse and exploitation of any kind of any children who come within the purview of the juvenile justice system, or who are staying in any residential care facility, or who are staying in any kind of non-institutional or alternative care arrangement. So firstly, to build a context for understanding non-institutional or alternative care, we must be very clear about why institutional care must be the last resort for children. It is best that children grow up in their family. It is best that children grow up amidst their own people, their own community, their own kinship care facilities. But for some reason, if children are not able to grow up within their own family, or for some reason the family is unable to provide for the child, or for some reason the family itself is found unfit or unsuitable for the child, then family-like based environments, family-based environments, alternative care environments, non-institutional services would be the ideal form of care for such children. When we promote and advocate strongly for alternative care, or non-institutional services for children, we are also promoting and advocating the child's right to a family, the child's right to grow up with parental care, with siblings, with extended family members, and if the child for some reason cannot grow up with his or her own family, then the child goes into as family-like or as family-based arrangement as possible so that the child grows up secure, happy, self-confident and become productive adults and happy adults once they attain adulthood. So do promote alternative care, do promote non-institutional care, read up more on this subject, read up the Juvenile Justice Act, read up the write-up. Also read up all the other modules within this paper on juvenile justice to build a thorough and comprehensive understanding of all children who come within the juvenile justice system, which are the children who would be eligible and entitled to alternative care, and then we can work in a very child-friendly manner, keeping in focus the best interest of the child. Thank you very much.